Good morning, everybody. We'll get started in just a minute. We'll get started in just 1 minute, just giving everybody a time to get on the Zoom. Well, welcome again. And I want to make a special thank you to Squire Patton and Boggs for putting on this program. I had reached out to them because I thought a lot of people would be interested in the subject. So they were very willing to do it, and I really appreciate it. And for their sponsorship of our chapter. Just a reminder that you have to be on the webinar for 15 minutes to receive the CLE. There will not be any code at the end. I track your time on the platform, and the CLE certificates will be coming out in a few days. Also, if you have any questions, please feel free to put them in the Q&A and chat. And at this time, I'd like to introduce George Gamas, who's a partner in the global law practice of Squire Patton Boggs, where he chairs the firm's international trade and national security practice. George has experience in all controlled technologies regulated under the International Traffic in Arms Regulations and the Export Administration Regulations. Mr. Gamas also leads the firm's CFIUS practice, submitting 5 to 10% of all notices received by CFIUS annually. And at this point, I'll turn it over to George. Thank you, George.
Hi there. Thanks so much. Thanks for that introduction. I think if you do put questions in the chat, I should be able to see them. I have the chat box open. I'll try to keep an eye on it. But if anyone notices I'm not seeing the questions, just let me know. Look, I'm assuming that a lot of the folks that are on this webinar may not be expert in export controls and economic sanctions. So I have tried to keep this at a level that is not too focused on acronyms or citations to regulations or anything else that's wonky. I want to keep it at a level that's really useful to you, and you know, again, just stop me if it's confusing or if I've used words that don't make sense to you. You know, this image just tracks the developments following the Russian action in Ukraine, and the big actions were on the 22nd, when many of the sanctions were put in place, and on the 24th, when other sanctions and the limitations on exports, re-exports, and transfers to Russia were put in place. And then you can see just more has been piled on, and this goes through March 11th. Even more has been added since then. I'll touch on a lot of these developments throughout our talk. If you want to keep track of developments in real time as they're occurring, you can go to this blog, tradepractitioner.com, and you'll see the part that I have circled on the screen. We have a tracker there of the updates or changes to the sanctions or export controls related to Russia. Now, in the United States, we have 3 different sets of regulations that comprise our export controls and sanctions regime. The first is the International Traffic in Arms Regulations, or ITAR, which is administered by the State Department, the Directorate of Defense Trade Controls, or DDTC. We don't really need to talk about the ITAR much during this discussion. In fact, this is the only mention I'll make of it, because when Russia invaded Ukraine, DDTC put in place a suspension of licenses and and stopped approving new licenses related to Russia for items that are under their jurisdiction, mostly military, but not exclusively military items. And so they haven't had to take any further action because of the recent events. The next is the Export Administration Regulations, or EAR, administered by the Commerce Department, Bureau of Industry and Security. And in the EAR, you will see something called the Commerce Control List, which is a list of all different kinds of controlled items. I mentioned these terms because I'll use them later, and I just wanted to have a chance to define them for you. So many of the developments that we'll talk about are under the EAR and administered by BIS. The third is the regulations under the Office of Foreign Assets Control at Treasury. Now, when you look at the sanction, Treasury has a different program and a different set of regulations for each country or each program that it administers. So there are certain programs like Cuba, Syria, Iran, North Korea that are comprehensive sanctions, meaning we can't have any dealings with the country, we can't export to them, we can't do anything with those in the country or with people from that country, organizations in that country. Then you have what was just the Crimea region, but now also is the other separatist regions in Ukraine, which are almost like comprehensive sanctions. You'll see why as I go through this. You can essentially think of them as comprehensive sanctions against those regions. And then we have these vast numbers of organizations that are on lists that you may have heard of, specially designated nationals or SDNs, or on an SSI list. And that's where really the vast majority of the sanctions involving Russia are placed. They involve listing organizations and persons as SDNs or on a list. Now, when you think about Russia and doing business with Russia, it's not at the same level of Iran or Cuba or Syria, North Korea, but actually it's not very far away either. So really what you should start from the position of thinking that you can't do business with Russia and then look for an exception that allows you to do business with Russia, rather than the other way around, thinking you can and making sure there's not a prohibition, because you'll see how extensive these prohibitions are. And in some ways, I think that the U.S. government has gone very close to the line of placing Russia in the same category as those fully embargoed countries. So I'll talk about this in three under three headings. First is the developments related to U.S. export controls. Second, the developments related to U.S. economic sanctions, and then third, trying to address the topic provided by the organizers about contracts and negotiating contracts. I would like to talk about trade contract compliance. I don't know if I can tell you how to negotiate your contracts, but I can tell you about the types of situations that we've seen and what the compliance issues are. And hopefully that will be helpful to you. I'm happy to discuss it or think about it with you during this call. So let's start with export controls. So the EAR is requiring a license for the export, re-export, and transfer in country of most items from the United States going to Russia. Now, there's a certain type of item, which we call EAR 99, which simply means that it's an item that is not actually described on the Commerce Control List I mentioned at the beginning of the talk. So if we go through this Commerce Control List, which is a long list of control parameters that control all sorts of things, and we can't find an item, a description of an item on that list, we just call it EAR 99. So it means everything else that's not actually on the list. So if it's just about everything that is on the Commerce Control List, now would require a license for export, re-export, or transfer in country to Russia. Now, beyond that, all items, including EAR 99 items, so all items that are made in the United States or are in the United States and are destined for a military end user in Russia will require a license. Now, these terms, military end use and military end user, you can see are fairly broad terms. Let me just pick out a few parts of these terms to really help make the point. So a military end use has to do with a use of an item that would come from the United States that would be incorporated into a military or other control type item. But when you look at military end user, it covers a lot of organizations that you think of or parts of the government that you think of as a military user, but it also covers any person or entity whose actions or functions are intended to support a military end use. So this would indicate to us that you don't have to be, say, even a company that you might think of as a government contractor. It could be more removed than that. So any organization that's engaged in functions or actions that would support that military end use of creating, of incorporating items into a military solution would be classified as a military end user. I mean, this means that to sell anything to Russia, even things that aren't on a list, you'll have to really give consideration to whether what the end use is and who the end user is of the item, and probably satisfy yourself through your own due diligence and possibly through certification from the customer in country that there's no military end use or military end user involved. So that deals with items coming from the United States, and those items are subject to the EAR, again, for export, re-export, or transfer. So that means, just think about it this way. Once the item leaves the United States, it's as if these regulations, the EAR, attach to that item and follow it around after it's left the United States, right? Well, that also is true when items are used to make items in other countries. So I want to just talk about how this applies to foreign-made items that are destined for Russia. There's two different rules we're going to talk about. One of them is called the Foreign Direct Product Rule. And again, trying to keep this at a higher level and not get too into the weeds. In some ways, my slide might overstate the problem, but I think it alerts you to the issue adequately. And it is this, that a license may be required for a foreign-made item that's outside the United States if that foreign-made item is the direct product of U.S. origin technology or software. So if the production of that item outside the United States used U.S. origin technology or software and it's destined for Russia, it may require a license. Or if it is the output of a plant or a major component of a plant, when that plant or major component of a plant is itself the direct product of this U.S. origin technology or software. What this means for foreign companies is that they need to look at the production equipment in their plant to see if it's equipment that came from the U.S. or is based on U.S. technology or software. And if it is, then the output of that plant is subject to the EAR potentially and may require a license to Russia. Well, it requires a license if you have knowledge that the item is destined for Russia, or if you have knowledge that it will be incorporated into or used in the production or development of a part, component, or equipment produced in or destined for Russia. Now that's true for these foreign-made items made anywhere around the world, except in certain excluded countries that are cooperating with the US. And I'll come on to those in a moment. The other rule that I wanted to tell you about is called the de minimis rule. Now, under the de minimis rule, we look to see if the US controlled content in a foreign-made item is de minimis or more than a de minimis amount of controlled US content. So this is a ratio essentially comparing the value of the US controlled content in the numerator and the value of the foreign-made item in the denominator. And this is a rule this is not a new rule, but what we place in the numerator is not all US content, but only controlled US content. And so in the past, before the new requirements I've just described, for Russia, we would only put in the numerator items that are on the Commerce Control List and have what we call an X in the box or are designated as licensable to Russia, which was not, by far everything on the list. Many things weren't designated as licensable to Russia. But now, because everything on the list, almost not everything, but almost everything on the list is licensable to Russia, it means there's far more things put in the numerator, which means there's far more foreign-made items that are subject to the EAR because of the US content. And for Russia, the de minimis level is 25%. So we're looking to see if that ratio is less than or more than 25%. Let me see, I have a question here. If the supplier is not the exporter on record, but a supplier in the supply chain to another US company, what's the supplier's responsibility if the supplier becomes aware of the ultimate destination is Russia? Okay, so now, I don't know from this question where that supplier is located, but let's just say for a moment that we have a supplier in the United States who is going to supply something to another company in the United States, and then they're going to ship something to Russia. Is that first company, this we'll call them the supplier, are they liable for that sale to Russia? And the answer is it depends on what they know, right? Because if the first company knew that this item was going to Russia, incorporated into something by the second company and then going to Russia, then they should have confirmed with the second company that the second company intends to comply with the rules or is going to obtain a license or receive some confirmation of that type. If they had no idea, like they supply to numerous companies, they supply things to this certain company, which may or may not be supplying something to Russia, and they didn't know, they wouldn't know in the normal course of business, then that's fine. The US enforcement authorities aren't going to hold that supplier responsible. So it really depends on what they knew, or another way, what they should have known based on the relationship. Okay, I think that answers that question. And that kind of wraps up the this de minimis rule for me too. So let me move on. I mentioned that there are some countries that are excluded, and these are countries that are putting in place comparable regimes. So this means that this expansion, if you will, of the de minimis rule and this expansion of the foreign direct product rule is not going to apply in the listed countries, because we expect those countries to have similar types of regimes that will will require a license anyway from those countries. And so we don't need to add on to that licensing requirement an additional US licensing requirement for the item. So that's the UK, Australia, and Canada, the European Union, Japan, New Zealand, and then just recently South Korea was added. There may be other countries added over time as they join in trying to implement similar controls. Now, I did not say as I went through these rules that exporting, re-exporting, and transferring items of the types I've described to Russia is prohibited. I've said it requires a license. And so let me talk about the licensing policy. There is a policy at the Commerce Department to deny the licenses. Now, that is different than, it's not the strongest or most restrictive policy Commerce could have. Commerce could have a presumption of denial. A policy of denial indicates that there are some transactions that will be licensed. And in order to obtain a license, there's essentially two things you'll have to demonstrate. One is that the transaction fits within a policy of denial exception. So these are safety of flight. You can read the maritime safety and space cooperation and other areas where it's been decided that transactions supporting those activities are eligible for a license. So you'll have to establish that and then justify the license. And justifying the license probably will mean, in most cases, establishing that the license is not going to benefit the Russian government or its defense sector. There's also other license exceptions in the EAR, some of which remain valid and useful for Russia, but we'd have to look at those on a case-by-case basis. BIS has taken a number of other actions. Firstly, everything I've said about Russia has been extended to Belarus. You may have heard of a list called the entity list, or the military, or another list, the military and user list. Companies have been moved around from the MEU list to the entity list, which is more restrictive. Other companies have been added to both lists. So there's expansion of the use of those lists. As I mentioned earlier, there's a license requirement, not just for Crimea now, but also for the separatist regions. There's a particular target of the oil industry, such that there's certain items that are going to require a license when they're for oil and gas exploration or production in deep water, Arctic or shale. But then there's another list of refining items that will always require a license for Russia, again, even if they are EAR 99. And then luxury goods destined for Russia and Belarus are now licensable. And there's a list there at Supplement 5 to Part 746. But if you were to go look at that list, I think you'd see there's a lot of items on that list that you might not think of as luxury items. There's auto parts, there's rugs, marine rafts, and some other things. All right, so now let me give you an update on the developments involving economic sanctions. This is under OFAC. And this is almost all list driven. And so what this means is that if you search the list and you don't find a counterparty on the list, then there's not a sanction. In most instances, you don't have to concerned about the sanctions. So who's been added to the list? Well, first of all, there have been a number of block persons added because they are deemed to be acting for the government of Russia, or that they're operating in certain sectors that we're trying to target. This would be the reason many oligarchs and their companies have been put on the list. There's key Russian banks have been placed on the list, so we can't deal with transactions involving those banks. Sberbank was not put on the full blocking list, mostly because it would be too much of a burden for Europe because of the prevalence of Sberbank and its subsidiaries in Europe. But we've done the next best thing and prohibited U.S. financial institutions from processing transactions for or with Sberbank or any of its subsidiaries. And then a number of Russian entities that have not been totally blocked were put on the list for purposes of preventing new debt or new equity being extended to those entities, which I'll just mention would be a problem, for example, for vendor financing, because you'd be extending credit to those entities. Other activities that have been blocked, again, the blocking of the separatist regions in the Ukraine, prohibitions on imports of oil and petroleum products from Russia, prohibitions on new investment in the Russian energy sector, and then prohibiting certain imports. You could think of it as, alcohol, vodka, caviar, and diamonds, for example, to give you an idea of what we're talking about. All right, so that kind of covers the developments. I have a question here. Are you aware of any banks in Russia with which it is safe and legal to transact business? There isn't a safe list. And I haven't tried, we have not tried to put together a safe list. So as far as I can say, you'll have to just check to see if the bank is not on a list. And let me get into that because that's complicated. So I've in trying to think about how you might want to address transactions involving Russia, I've broken it up into three categories: sales to Russia, procurement from Russia, and then operating a business or a subsidiary in Russia. So on sales to Russia, you will need to screen all the known parties to the transaction. We have to determine if they're on a list. Now, I have given you here a link. Actually, it answers the question I think that just came in. Here's a link that you can use for screening parties. Now, this is a government site. It's free. You can put a name in. You can search for a party. It is not as good as paid for services that allow you to search, and importantly, it does not look at the ownership of the party that you're searching. So it only searches on the name. The reason that's a problem is that on a number of these lists, many of the there is this 50% rule, which means that if a company or an organization is 50% or more owned by block parties or parties on a list, then it is treated as if it's on the list, even though it's not on the list. So if you ran a search against, let's say, the subsidiary of a block party, it might not come up when you run the search on the list, because that company is not on the list, but its parent company is, and therefore that company is actually deemed to be blocked or sanctioned at the same level as its parent company. So if you're going to use this tool, which is free, before you can really use this tool, you'll have to do research into the ownership of the party. You'll have to know who owns the party, and not only search on the name of the party, but search on the name of the owners. Now, to add a bit more complexity to this process, if you thought about sort of best practices in running these types of searches, a number of companies might take the view that, look, we're going to search, we're going to use the best information available to us, whether it's some paid service like Dun & Bradstreet or internet searches or whatever we can do to identify the ownership of the counterparty. And then we'll run searches on the counterparty and its owners. But, there's a possibility we might not know who the owner is or who all the owners are, right? And so long as there's no information derogatory, no information that we can find of ownership by a blocked party, we'll proceed with the transaction. Would it be a violation if you went about that process and in fact it turned out that it was the company actually was owned by a blocked party? Yeah, it would still be a violation, but that wouldn't be an enforcement action, right? Because OFAC would and BIS would expect that you've done your homework and did the best you could to identify the parties and search. I think that when it comes to Russia and sort of the intention of capturing, the financial institutions and the huge sectors of the economy, that probably a more enhanced screening is indicated, which means that rather than searching just on what is knowable, that you should require that you know who the owners are, which goes beyond, I think, what a lot of companies would consider to be their normal practice. That's why I call it an enhanced screening. So I think that really it means looking at, not just determining what's available, but if the information does not, if you only can track down 49% of the ownership interest, you can't proceed until you find the rest of the ownership interest, which might mean asking the company to provide that information and certify as to the accuracy of the ownership information so you can run the search. So that's a more diligent level of screening the party to the transaction. In this case, a sales transaction, the customer, the intermediaries, the ultimate end user, screening the parties more thoroughly than we normally would do. But even beyond that, I suspect that very few companies would do this in the normal course before these Russian-related sanctions. Even beyond that, I think you need to screen the financial institution involved in the transaction. So your customer is going to pay you. And when they pay you, they're going to use some financial institution. If that financial institution is blocked or owned by a blocked entity, then when those funds hit the US bank, those funds are going to be blocked. You're not going to receive those funds, and those funds are not going to go back to the customer. They're going to be blocked. And so really you should ask, you'll want to screen the financial institutions that the customer is using. There's a question about paying a law firm. Let me come on to that on the next slide because I'm talking about procurement, which is more, it fits better into the procurement discussion. So help me remember to do that. But on the sales side, I think that's the kind of effort you have to go through. I think you also need to really pay attention to the export classification of the item you want to export. Obviously that should be done anyway, but considering that, anything that's on almost anything on the commerce control list that you might want to send to Russia would require a license. It just is even more important to get the export classification right. And then, as I talked about, you have to confirm that you're not, selling directly or indirectly to a military end user or military end user, even if you can get through all these other hoops and decide it's okay to conduct the transaction. You probably want to get a certification from the counterparty as to the parties involved, the banks involved, the end user and the end user, all that information certified for your records, so that you have an auditable record if enforcement authorities have a question about your transaction. Is there any situation, I think it should be when a non-export US supplier should be required to screen the Russian end user with the 50% rule? Well, I think this goes back to the same comment I was making earlier. In this example that's being presented, we're talking about, I think, a company in the United States who is not planning to do the export. They're going to sell to someone else in the United States who will do the export. And that company who's doing the export is primarily responsible for doing the screening and making sure there's no problem. But you can think of situations where the supplier is supplying something unique or special or custom, where they know it's going to Russia and they know what they should have some idea of what it's going to Russia, what the end use is in Russia. And so in that case, arguably they should do some screening of the parties. If they're supplying something that is more common or isn't customized for the end use, or where they just wouldn't have information about the fact that it's going to Russia, or even if it is, who would be the buyer in Russia, and they expect that their customer in the US is doing the screening, that should be fine. Okay, so next slide. Now, procurement from Russia. Let me just start off with the question I had earlier so I don't forget about it. Is there an issue with paying a law firm in Russia to renew a trademark registration in Russia? Well, I guess you'll have to go through the process that I've described here, which is you have to screen the parties in the financial institution. So you're going to work with a law firm in Russia. You should screen that law firm in Russia and make sure it's not on a list, or it's not the partners that you're working with, or maybe all the partners aren't on the list. And you'd want to make sure also that when you pay them, that the bank you're paying in Russia is a permitted bank. And that's probably the more important point, because maybe it's not that likely that the law firm's going to be on a list or will be owned by somebody on a list. But if the law firm's bank account is a sanctioned bank or owned by a sanctioned bank, when you go to ship the funds, your bank is going to block those funds. So that money will never go to Russia, and you won't get that money back. It's going to be blocked in the United States by your bank. And these, the banks in the financial institutions are very diligent about these issues, and they are doing extensive work to understand who are the owners of different financial institutions and of other entities in Russia. So they may even have information about a counterbank in Russia that you can't even find out. So it probably would be a good idea, not just for paying your lawyer to do the trademark registration, but for any transaction where you're selling into Russia, it'd be a good idea to talk to your bank ahead of time about the transaction and the party that you're paying and the bank that you're paying through their bank, to make sure that your bank doesn't see any problem with the transaction. Now, it's possible that their position may be more conservative than is actually legally required because from their own compliance position. But still, I think it's useful to have that discussion. And if you have to, if you have to go to a different bank because you don't agree with their conclusion, then you could do that. But you don't want the funds blocked because when they're blocked, then also the bank is going to report to OFAC that they blocked the funds. They're going to report the transaction. And so you may be getting questions from OFAC. So again, in engaging in a procurement from Russia, screen the parties, screen the financial institutions the same way we talked about on the last slide. Confirm what you're importing is not prohibited. There aren't very many things that are imported that are prohibited, but still there are some. Keep in mind that some procurements actually also involve exports. In other words, if I want to buy a piece of equipment from Russia, I might need to send to the manufacturer in Russia information about the application in the US or the interface of that equipment with other equipment. And those communications about the application and the interface control documentation or other documentation is an export of technology. So we need to make sure that those exports are authorized. And then also recognize that you cannot have US dollar cash payments. Some companies have thought, all right, look, we can't use the banking system in Russia, or it's hard to find any bank that can use in Russia. We'll pay them in cash. You cannot make US dollar cash payments to parties in Russia. All right, next slide. Talking about having a subsidiary or an affiliate in Russia. There's going to be problems making payments on behalf of that subsidiary or affiliate in Russia. So even making your payroll to your employees in Russia, paying for your lease space, paying suppliers or contractors, all of those transactions, even though those are transactions by your subsidiary, potentially are prohibited. We have to look again to see what banks are involved. So paying into your employee's bank account at a sanctioned bank is a violation. Paying the lease to a sanctioned bank is a violation. Now, arguably, if this happens all in Russia by your Russian subsidiary, which has its own funds or its own income stream, might not be subject to those sanctions. But what we have found in our discussions with clients is that even in those situations, there's some sort of facilitation or approval from the US, or to say it a different way, those Russian operators are not operating completely independent of the U.S. Parent company. And that facilitation or approval by the U.S. will be a violation. Procurement question. What level of risk is involved if a vendor has Russian subcontractors? That's a good question. And we've seen that raised both by our clients who are in that exact situation and also clients who are working with the Russians, and their customers have that question. This is really a risk for the company doing business with the Russian vendor. They're the ones who are running the risk of having transactions blocked because there's a sanctioned bank involved, or run the risk of violating the EAR by transferring technology or software or something like that to the Russian vendor. Generally, if the item has come into the United States and it's not on the list, which again is limited to things like vodka, caviar, and diamonds, it's not a problem for you to buy that item from the vendor. I think it would be important to get confirmation from the vendor that they're aware of their compliance response obligations and that they are acting in a way that is compliant with U.S. export controls and sanctions. Not because it's really your responsibility to police it for them, but just to avoid any appearance that there's, you're in some way complicit or, aiding or facilitating their violations. I think that'd be a good practice. Slides will be posted. I don't see any other questions right now. Yeah, the slides will be posted on tradepractitioner.com. Yeah, and if you go there again, you can get, that's where we post our updates on the sanctions and export control developments. And that's all I had for you today. So I'll let me just see if there's any other questions before we wrap up.
Thanks so much, George. Did you see the procurement question?
Yeah.
Okay.
This is, they're asking about the level of risk if a vendor has a Russian subcontractor.
Right.
Yeah.
Okay, great. Thank you. I hope things don't get too crazy for you.
Oh, not to worry. We don't complain about these things.
Yeah. Well, have a good day. And thanks again for doing this.
Yeah, happy to do it. Thanks everyone for participating. Hope it was useful to you. Bye-bye now.
Bye-bye.